On behalf of Eulogio, Lisca, we are here seeking reversal of a final judgment entered as a result of a default. In this case, the original sin, if you will, in this case, was the allowance of an amendment to the complaint to add a count for declaratory judgment that was seeking the same relief that was, I'd like to reserve 5 minutes for rebuttal. Thanks.
Okay. When the yellow light comes on, you will be into your rebuttal time.
Great. Thank you. The amendment for declaratory judgment was seeking the same relief that had been previously denied to the defendant in a motion for summary judgment, not once but twice on rehearing, which was the request for determination that the plaintiff was not a material man, which would have given the defendant workers' compensation immunity. The plaintiff defeated summary judgment. Rehearing was asked for. The plaintiff defeated that. Subsequently, the defendant asked for leave to amend to file a counterclaim for declaratory relief to declare that the plaintiff was not a material man, the exact same relief they had sought in the summary judgment motion that they had lost. This is improper. There's a case directly on point out of 3rd DCA, the Garcia case, where identical thing happened, and the court said you can't do that. You cannot seek the same relief. If you have the ability to adjudicate the issue within the present lawsuit that you have, you cannot go file another claim to resolve an issue, especially when you've already lost the issue on summary judgment. That's exactly what happened in the Garcia case.
Well, maybe that's all true, but aren't we really here because of the default? So don't we have to deal with the issue of the default first?
Well, I think it's the other way around, because if the counterclaim was never filed, there would have been no default. So we start from the premise that the counterclaim in and of itself was improper. And the argument was made, it was preserved down below by what they said. The exact case that I'm relying on here was cited. So if leave to amend is never granted, there is no counterclaim, and then the series of errors, a comedy of errors, if you will, that
It may have been a legal error, and we can discuss that later on, but it doesn't render it a nullity. I mean, there's still compliance issues, aren't there? So even if it's a legal error that it was entered, aren't we still at the point where there still has to be a response, there still has to be an answer or something, and
of course, there is an obligation of the plaintiff to follow up and do what they needed to do, but that doesn't mean that we can't cure the error on plenary appeal. And the initial error is the allowance of the amendment in the first instance. But I'm happy to address your questions regarding the default in and of itself. The default was inappropriate for 2 reasons. One, procedurally, there was a motion for rehearing pending at the time the default was entered. The order granting default says specifically, I am granting default, and I am denying your motion for rehearing at the same time. There is no set of circumstances under the law where you can grant a default while a motion for reconsideration is pending.
But it was happening all at the same time, correct?
Exactly.
I mean, does the judge even have, I mean, the motion for rehearing goes to the discretion of the trial judge. This is a interlocutory motion for rehearing. It's technically not even authorized, correct, by the rules?
No, it's a motion for rehearing is a specific pleading that is authorized under certain circumstances. A motion for reconsideration can be made at any point. It's not specifically set forth in the rules. Rehearing applies to time frames for various points that would not, either you toll an appeal or you don't toll an appeal. That's not what we're dealing with here. A judge can reconsider his interlocutory rulings at any point, and you have a order that's entered ex parte because the plaintiff's counsel isn't there, and she files a motion for reconsideration after that. The law is very clear. If you have a motion pending, regardless of whether it's authorized, regardless of whether you were told to answer or not, you cannot enter a default under 1.500B, period.
But it's all being done at the same time, isn't it? I mean, what?
It doesn't matter. There's a pleading pending. You can have a motion for extension of time. He has cited no authority to suggest that you could enter a default if there's a motion pending.
At the same hearing, and he said, okay, I'm going to deny the motion for rehearing, and now I'm going to enter the default.
You can't do that because there's a motion pending. The default means that you could file. You can file a default under 1.500B if you have not filed a responsive pleading, period. That's it. If you want to sanction the plaintiff's counsel for their intransigence, for not following your orders, you can do that. But you have to meet the Cozell test for that. And defendant has conceded. They didn't even respond to the argument regarding sanctions, even though they cited a lot of the conduct. Conduct of the plaintiff has nothing to do with whether a default can be entered under 1500B.
Well, I agree that the conduct of counsel was a different issue for purposes of this discussion, but 1.500B says if they have filed something, you are to serve them with a copy of the application for default. It doesn't say that you can't rule on anything else at the same time, but it says, provided that if such party has filed or served any paper in the action, that party shall be served with notice of the application for default. It's not, the counsel was served with the application for default, I believe.
Well, that's two separate things. That's if you file a notice of appearance, and then they haven't filed a responsive pleading, then they have to be served with the notice for default.
Correct. That's what the rule
Right.
says.
Right. So that's not talking about a responsive pleading. That's talking about if you filed anything in the case at all, so you know who your opponent is. They know who the opponent is. They've been litigating this case for 4 years at this point.
But where in the rule does it say that the court can't enter a default? You cited 1.500B. I'm confused as to why the judge wouldn't be able to rule on the motion for reconsideration at the same time within that rule. I mean,
The rule requires you can only enter it if there hasn't been a responsive pleading filed. A motion for reconsideration is a responsive pleading.
Do you have any cases that?
it says has failed
Yes,
failed
I do,
to
Your
plead
Honor.
or otherwise defend as provided by these rules,
Right.
or any order of the court.
And that's defending. When you file a motion for reconsideration, you're defending. If you file a motion to dismiss, you're defending. If you file a motion for extension of time, the cases I've cited on page 14 of my initial brief, Your Honor, the Pinnacle Corp versus R.L. Jernigan, motions for an extension of time extend the deadline beyond its prescribed date pending a ruling on the motion. The Becker case, clerk's default may not be entered in the face of any written communication that informs the plaintiff of defendant's intent to contest a claim. And the Russell versus A.G. Edwards case, a motion for rehearing/reconsideration satisfies the definition of otherwise defending against the action to preclude entry of default by the court.
But at a certain point, the motions were denied, and the court specifically said you have 10 days to respond.
That's correct. There was the initial order said 10 days to respond. At that point, a motion for relief from the order was filed. The subsequent order filed in April of 2013 said you have 10 days to answer. A motion for reconsideration was filed at that point. So there's a series of cases which I've cited in my reply brief that deal with let's start with, let's see here, the Pierce
And
case.
So then more than
That's-
8 months go by, and then there's no answer filed.
They filed a motion for reconsideration. That's a responsive pleading.
But did they call it up during that 8-month?
No, the first hearing date was the date that it was argued on September 18th, 2013. So that was 4 months, 5 months. So at that hearing, the court says, I am going to hear their motion for default, I'm going to hear your motion for reconsideration, and I'm going to rule. He says this. And then his order doesn't say, you disobeyed me, I'm not considering this. It says, I am granting the motion for default, I am denying your motion for reconsideration. That means there is a pleading pending that satisfies your obligation to respond.
But didn't the judge of the prior hearing say, I'm not going to hear the default today, I'm going to hear it, you need to schedule it at a motion calendar hearing, and I think specifically said to counsel for the counter plaintiff, of course, if they answer before that hearing, we're not having that hearing. Didn't the judge give every opportunity and every indication that this is what is going to happen at that hearing if you haven't answered by that time?
The judge did give them indication, but he didn't issue a ruling at that point. And we have to deal with rulings here. And I'm not here to defend the conduct of plaintiff's counsel below. Ideally, they would have answered the complaint as ordered. But the question is does their failure to answer and file a different pleading instead result in the dismissal of the plaintiff's case who had nothing to do with this?
Well, he did
This
issue
is
a
the
ruling.
ultimate sanction.
He said, I'm not extending the deadline for you to respond to the counterclaim. You need to respond, you need to file your answer.
That is correct. So I'm not extending it. But remember, there is a motion to extend pending and a motion for reconsideration. So to the extent that that constitutes an ore tennis ruling, now remember, there wasn't an order answered. It would only apply to the motion to extend. Okay? The judge heard argument on reconsideration on September 18th. He ruled on it. He issued a written order denying it at that point. Okay? So he didn't do that beforehand. If he had said, I already ruled on this, we'd be having a different conversation. He didn't say that. He says, I'm going to hear it, I'm going to rule on it. He issued a written order on that date. So that's what we're dealing with. That's the universe of what we're dealing with here. We're not talking about defending this behavior here by the plaintiff's counsel. We are talking about, should this result in the dismissal of this lawsuit?
Well, aren't you really saying that if you look at all the little technicalities, they weren't followed to the T, and therefore this should be a reversal, as opposed to looking at the bigger picture and saying, look, you have a lawyer that's not responding to the court on multiple times. Everything's happening at the same hearing. The judge just says one thing before the other, but it's really happening simultaneously. It's just like putting form over substance, aren't you?
You have to put form over substance here, because this is a dismissal. This results in the dismissal of the lawsuit. This is the ultimate sanction, and in order to do that, you have to make sure it's done properly. If you're going to sanction plaintiff's counsel for their conduct, that's fine, but you have to do it right. Cozell requires you have to have written findings, and you have to set forth the basis why this disregard is contumacious and willful and merits this kind of sanction.
What if it's not a sanction? What if it's just
Then it's,
by operation
then it's
of rules?
procedurally improper, because there is a responsive pleading filed, and there are no cases that the defense has cited. There's not a single case that says you can enter a default while the motion of reconsideration is pending. Whether that motion is proper or not, whether it shouldn't have been filed or not, there is a motion of reconsideration pending. You cannot enter default. That is what the law says.
A responsive pleading is not the, I don't think it's the same as a motion. Now, the cases that you cited earlier saying motion for extension of time requires you to do something, and clerk can't enter a default if something happens. Those aren't really talking about responsive pleadings. They're all kind of unique circumstances of how procedurally you can do something. A motion to dismiss is not a responsive pleading. An answer is a responsive pleading. So I'm not sure, you're kind of, although you want us to be very technical about how this went down, you're kind of using that word in a very
Well, hold on. I respectfully disagree that if you file a complaint and I file a motion to dismiss, you can't enter default against me. So it's a responsive pleading. You're defending the case. And then if you deny that...
I will agree with you about
Yeah.
you can't enter the default, but I'm not saying that a motion to dismiss is a responsive pleading.
Okay, if you don't like that term, that's fine. But it is a pleading filed in order to
There's
defend the
something
case.
filed.
And the Russell
It should
A.G.
be a
Edwards
pleading,
case... I'm sorry?
I think the cases talk about motions not being pleadings.
Pleadings, right.
If I'm using the term improperly, that's fine. If it's a motion, it still qualifies. You look at the Russell A.G. Edwards case, a motion for rehearing or reconsideration satisfies the definition of otherwise defending the action to preclude entry of default.
So then you should be using otherwise defending the action, I think.
That's fine. I'm happy to use that if I'm using the responsive pleading
And
term
because
improperly.
you're running low on time, if you could just briefly address, I think, what was your last argument, that let's assume the court was correct to enter the default, or putting that issue aside, that because the judgment was void, it could be set aside, and the motion to set aside should have been granted.
Thank you. On that point, we go back to the original part, which is that the counterclaim in and of itself is void for lack of subject matter jurisdiction under Garcia, and it doesn't fail to state a cause of action. If it's void, then you can set aside the default. There is no requirement of due diligence, excusable neglect, or any of these other issues, because that is, when you have a void counterclaim, you can raise that issue at any point. There isn't a timeliness issue, and it was 2 months after that was filed. And due diligence is when you have someone who's not even involved in the case. They discover a default has occurred. They have an obligation to act on that as quickly as possible. Those cases do not apply. We cited 4 cases that specify that. The defendant did not identify any cases that state otherwise. So due diligence is simply not an issue in this case. I'd also like to save my
I'll give you a couple
rebuttal.
minutes for
Thank you.
rebuttal. Mhm.
May it please the court. My name is Michael DeLugo from the law firm of Wicker Smith in Orlando, and I'm here today on behalf of Florida Atlantic Construction. This is really a tale of a succession of 4 orders that were entered by the trial court and the propriety of the entry of those orders. One was an order granting Florida Atlantic leave to file the counterclaim. One was an order denying a motion to dismiss that counterclaim. One was entry of an order granting the motion for entry of a default, and the last one was the order that refused or denied the motion to set aside that default.
Do you agree that the judge shouldn't have allowed the counterclaim to the
I do not.
vote?
I do
Why
not. Under
not?
the circumstances of this case, what we have here is a split in authority, and Mr. Lisca is arguing Garcia, and out of the third, and I am arguing Barrios, which is a case out of the fifth. And what the Fifth District Court of Appeals says is contrary to what the Garcia court stated in this sense. Under Garcia, and I certainly understand why Mr. Lisca is relying upon the Garcia decision, Garcia can be interpreted as being a blanket, absolute, you can never ever file a counterclaim that is based upon an order or an issue that has already been raised in a prior motion for summary judgment. That if you have the ability to get the relief requested in an already existing claim, then you cannot, as a matter of law, pursue a separate cause of action that raises the same issue. Barrios says that's not necessarily the case, that there can be exceptional circumstances that exist that would allow for the counterclaim to go forward. So Barrios rejects the concept that there is this per se prohibition against doing what the trial court did here. And I would submit to the court that the exceptional circumstances that would warrant the allowance of the counterclaim in this case would have to be the tortured procedural history of this case. To a certain degree, I believe it depends on how you define exceptional. If you define exceptional as being outside the norm, then this is an exceptional case. The procedural history of this case, with the motion for the leave to file the counterclaim, was filed 7 years after the cause of action accrued. This case has defied all logic procedurally as far as the course of matters. So I would submit that, and certainly if the court feels that Garcia applies, then I'm going to distinguish Garcia on a number of matters. I don't think that the court should apply Garcia. I think the court should apply Barrios. But certainly Mr. Lisca's argument is that there is this pro se prohibition against doing what the trial court did. I would submit respectfully that that is not the case.
If Garcia applies, is the amendment void?
It depends on which, there's a question of void versus voidable. And so if the court determines that under the application of Garcia that there was no subject matter jurisdiction to hear the counterclaim, then that was the error, then that is void. And I will concede that point. If instead the issue is that the counterclaim failed to state a cause of action for which relief can be granted, as opposed to lack of subject matter jurisdiction, then it's voidable.
And wouldn't that be because the court obviously does have jurisdiction to enter declaratory judgments.
It does.
Just perhaps if we were to follow Garcia as opposed to Barrios, they could not enter this declaratory judgment because they couldn't state a cause of action since it was already stated in that the original complaint. Is that your position if we were to go that route?
Our position is that you should apply Barrios and not Garcia, that Garcia is distinguishable, and for the very important reason that what they were trying to do in Garcia was they're trying to make an end run around the Florida Rules of Appellate Procedure and get a final appealable order on an issue that is uniquely within the legislative branch of government. The issue was whether or not a party has the ability to obtain 2 claims bills. And essentially what they were asking for in Garcia was an advisory opinion from an appellate court stating what the legislature can or cannot do, which obviously under separation of powers, the court can't do that. And so we would argue that Garcia is distinguishable and that under the circumstances of this case, what the procedure that was followed by Florida Atlantic Construction was permissible under the specific facts of this case, because what we were asking for was a determination as to whether or not Mr. Lisca was a material man at the time of the incident that is that's created the cause of action here. And so we would submit that based on that distinction, that Garcia doesn't apply and that you should apply the Barrios standard that says that exceptional circumstances would allow for the pursuit of a counterclaim under these circumstances, and that the exceptional circumstances that exist here would be the tortured procedural history that this case had followed to that point. And so We feel that the entry of the order allowing the counterclaim to go forward was appropriate. We feel that the order denying the motion to dismiss the counterclaim was also appropriate. And then there were just a series of motions for reconsideration, rehearing, just keep on pushing and pushing and pushing and not answering. And I'm glad, Judge May, that you brought up the issue of responsive pleading, because I agree.
I felt like I had forgotten my law school days.
No, I agree with you that a responsive pleading is not a motion, that those are two separate things, and that a responsive pleading in this context is an answer.
And yet the cases he cites seem to indicate that certain filings or motions can potentially prevent the entry of a default.
I agree that if a party is defending that you cannot enter a default, except under the unique circumstances that we have here, 1.500B does afford the trial court the discretion to enter an order of default under circumstances that we have here. And I cite to the opinion of the First District in Gulf Maintenance and Supply, where it says that the entry of a default is appropriate where the defendant does not intend to appear and defend the merits of the action, or, and I emphasize the word or, engages in dilatory practices in bad faith solely for the purposes of hindrance and delay.
So is that the same as entering an order as a sanction?
It is not. It is not. It is a procedural step that under the rules of procedure, and I want to make very clear that we are not arguing that this is a sanction. Okay?
Because you would lose that argument.
That's why I'm not pushing that. No, I agree with counsel for Mr. Lisca that the court did not satisfy the causal factors, and that's why we want to completely
But you would agree, a default is about as severe a sanction as you can enter for a plaintiff. But you're saying it's permissible under the rules as a process rather than a sanction.
That is correct.
And otherwise, you could always file a motion at any time as the judge is about to sign a default, which would render the default void or...
Correct. Yeah, I'm not. I believe that the trial court had the discretion to do what he did in this particular case, and you can read. It's important, I think, to read the series of hearing transcripts to sort of get a flavor of what was going on as this case ambled along during its course.
I read it as saying when a party against affirmative relief is sought has failed to plead or otherwise defend as provided by ... any order of court, and it seems like if we were to say that because there was a motion pending, a judge could never enter a default because you could always file something.
That is correct. And I would also like to point out or emphasize, I think that the court may have mentioned this before, that what 1.500B says is that when they're defending, that they just have to be put on notice of the application for the default. Well, clearly, the plaintiff was put on notice numerous times, not just through the written filings, but by the court's specific statement during the August 12, 2014 hearing, basically stating, if you don't answer prior to the hearing on the motion for entry of default, there's going to be a default entered. And counsel for Florida Atlantic, you understand that if there is an answer that is filed prior to that hearing, your motion for default becomes moot. And trial counsel for Florida Atlantic responded, I'll withdraw it. If they file an answer, I will withdraw my motion for default. So clearly, all of the parties were on notice of what was going on. And so, therefore, we would submit that under those circumstances, the trial court was within his discretion to enter the order granting the motion for default, given all of the procedural history of this case, and that further, when there was a motion to set aside that default, our argument is obviously that this was not a subject matter jurisdiction issue going back to the original counterclaim, and that therefore Mr. Lisca did have an obligation to demonstrate due diligence, excusable neglect, and meritorious defenses. There was never an affidavit that was filed to explain excusable neglect. There was never an answer at any point, and the trial judge at the motion for the hearing regarding setting aside the default made a point of that issue, of stating that there was no answer even filed at that point, so there were no meritorious defenses brought to the court's attention. And finally, the motion to set aside the default was, I believe, I want to say 10 weeks after the original order. We're going from September to December, so
It's actually fast considering the way this case moved.
in relation to the rest of this case, that is true, Your Honor. However, there are cases that we've cited in our answer brief that talk about how 4 or 5 weeks is not exhibiting due diligence. Really, you have to move as quickly as reasonably possible. And I believe, in my experience on this type of motion trying to set aside a default, that we're talking about days and not weeks.
In order for you to win, do you have to win on the first issue, or could you lose the first issue and still prevail on this?
If the court determines that the initial decision on allowing the counterclaim under Garcia was error because the court lacked subject matter jurisdiction, then I lose. I don't think that's true. I don't think that's the case. But
Appreciate your
I think
candor.
I think that the counsel for Mr. Lisca used a criminal phrase in his initial brief, which I think is appropriate. Fruit of the poisonous tree, and obviously we're not talking about illegal searches and seizures, but we are talking about an initial event that, from their perspective, sort of poisoned everything that happened in the years that followed. I would submit that that is not the case, that the court was within its discretion to do what it did, but I certainly acknowledge the argument that they're making.
Because I see under 1.500B, it says when a party against whom affirmative relief is sought. So if you don't have a counterclaim, you wouldn't be the party against whom.
That's correct.
Okay.
And unless the panel has any further questions, I will rely on the contents of the brief.
Thank you.
Thank you.
Try to go as quickly as possible here. The Barrios case that they rely on actually did not find that those exceptional circumstances existed. Barrios referenced the Taylor versus Cooper Florida Supreme Court case, which says it's the almost universal rule that you cannot seek this type of relief. So there's the Kais case and the Fox case out of the Fifth and the First. There are only about 5 cases that deal with this, and not a single one has identified exceptional circumstances that justify this type of relief. And as the Florida Supreme Court says, it's an almost universal rule. Barrios doesn't identify it, so there isn't a conflict out there. Barrios has said this isn't the type of relief. We're not going to allow you to file this counterclaim. So there is no authority to support the fact that there is a tortured procedural history which creates exceptional circumstances to allow this kind of relief. It doesn't exist. Your Honor, you asked about void versus voidable. That only matters in setting aside the default, and the only difference between the two is whether or not you have to act within a year. If it's void, you can act at any point. If it's voidable, you have to act within a year. Again, this was 2 months, so it doesn't matter for the purposes of this case. And that was this court's case in Condo Association of Lemaire versus Bank of New York Mellon, and that line of cases, including the Becerra versus Equity Import cases, that if it's void or voidable, you can set it aside at any time. That's why the excusable neglect requirements do not apply in this case. The Gulf maintenance case that they're relying on, I want to refer back, I want to read you a quote from that, but I also want to refer back to this court's case in Ziegler versus Houston, where it says, when a trial court enters default based on a party's willful and deliberate disregard of the trial court's prior orders, it is exercising its authority under Rule 1200C and not under Rule 1.500B. That's this court saying that, explaining that someone hasn't responded, you're sanctioning them. You're not using 1.500B. And what Gulf Maintenance says, the next paragraph after the quote that he read to you, it says, on the other hand, default is not appropriate in cases where the plaintiff knows that the defendant is represented by counsel who intends to assert matters in defense of the cause of action. The default rule has been liberally construed in Florida to allow trial upon the merits where all parties appear, rather than to encourage resolution of legal disputes by default. Gulf Maintenance does not provide authority to enter default where someone has filed a motion for reconsideration. There's 4 cases that I cited at the end of my reply brief in which the trial court ordered plaintiff to answer the complaint after denying a motion to dismiss. In those cases, the plaintiff did not obey the trial court, filed a different motion, if it was a motion for reconsideration, rehearing, whatever it may have been, and the court dismissed, entered a default for failing to respond to that. In all 4 of those cases, most recently in the Pierce case, the court said that is an abuse of discretion. You cannot do that. You can sanction them for that, but you can't enter a default because it is the ultimate sanction. This was treated as a sanction. This is not, you cannot procedurally enter a default if there is a motion pending, regardless of whether that motion was authorized by the court or it's in disregard of the court's order. You cannot take away somebody's case. as a result of that. You could have, he possibly could have sanctioned plaintiff's counsel if he had set out the Kozel factors, and that may have been appropriate in this case, but that's not what happened here. It took away the plaintiff's case, who had indisputably nothing to do with the conduct of his counsel.
And just, I know you're over time, but did you have a proposed responsive pleading attached to your motion to vacate the default?
No, Your Honor, we did not. We relied on the cases that said that because it's void or voidable, those cases do not apply.
Okay.
Let me ask you just briefly to address, there's some emails that are in the record from August of 2014. You want to comment on those?
Other than to say that I do not defend the conduct of plaintiff's counsel or the things that she may have said at that point, and that's why I said, perhaps sanctioning her may have been appropriate, but not sanctioning the plaintiff himself based on that conduct, because the plaintiff, there is no evidence that he had anything to do with the behavior of his counsel at that point.
Thank you.
So.
Appreciate your time here this morning.
Thank you.
Thank you.
That's okay. That will take us